My spouse has complete control over all of our finances. How will I be able to hire an experienced divorce attorney without him or her knowing?
Part of the answer is you want to use credit cards. So if your husband is a quote unquote moneyed spouse, that means they have property, they have assets. Apply for a credit card. Um, you can, especially if you're married, you can say, well, if you're filling out the credit card application, I don't have anything, but guess who does? My husband. Here's his income. That the house, even if it's just titled in the husband's name, it's presumptively marital property, especially if it was bought or accrued value during the time of the marriage. So you could put down that we own property, which is technically under New York state law true. Especially a property bought during the marriage is what's called tenancy by the entirety. Means even if your name is not on the title, you're still considered a co-owner of the property. The other thing too is, especially if you're about to file for a divorce, what assets are in your spouse's name, you will be making a claim that 50% of those assets should be your assets. So it's not, as a general rule, there might be exceptions to it, but generally speaking, it would not be considered credit card fraud if you put down your spouse's income and your spouse's assets and said, these are in effect my income and my assets, because you're going to be making that claim in the divorce case itself. So that is what I usually recommend. If a wife comes in and says, I'm a homemaker, I stay home and take care of the kids, I have no income, my husband has everything in his name, what do I do? That's the first thing that I tell them to do. Second thing that I tell them to do, if they say, well, I tried that and I got rejected by 5 credit card companies, then I say, okay, here's the backup plan. Borrow it from family members or friends. That's number one. Number two, you can also go to legal financing companies, make an application for a legal loan. Sometimes especially they're going to have you fill out a lengthy questionnaire. They may even pass it along to your potential attorney and say, what is the likelihood that you're going to get alimony, a share of assets, et cetera, et cetera. And that legal loan company will essentially assess on their end, here's our assessment of your credit worthiness to be able to extend you a certain loan. And sometimes that works. I got a loan one time for one of my clients. He was, I think, like 18 years old. He had just graduated high school. I don't even think he had a job. Certainly didn't have all that much in terms of assets. But when I got the application from the legal financing company, they said, well, what do you think your client's going to get out of the case? And I said, hey, I think he's going to get, close to $100,000 out of the case. And within a matter of weeks, I think it was, they gave him a loan for $20,000 to finance the case. Obviously they would want a lien on his proceeds, which they got. They obviously also have him sign the loan agreement. So if he, defaults, they can go after him. So that's the second thing that I would advise that potential client to do. There's a third option, which is under, at least in the greater New York City area. I'm not sure about outside the greater New York City area, but in the greater New York City area, all of the Supreme Courts have what's called the Office of the Self-Represented. If somebody completely cannot afford private counsel, they, exhausted all the aforementioned methods of getting money and came up dry, go to the Office of the Self-Represented. They have volunteer attorneys who will help you draft an application to the court for counsel fees. It's what's called a poor person motion. Now you have to fill out an affidavit that basically says, I have no income, I have no property, no assets to dip into, I've tried to borrow it, couldn't do it. I'm now applying to the court for counsel fees and assignment of a quote unquote pro bono attorney. When that attorney is assigned, they can come into the case. They can say to that potential client, okay, well, what are the incomes? What are the assets? What are the properties that are involved? And if they easily see that your spouse is the moneyed spouse, their immediate next step will be to file a counsel fee application so that they can get paid on the case. So invariably, one of those three things are going to happen. Now, obviously, if both spouses are poor, then you're probably not going to get money to be able to hire a private attorney, in which case you'll either have to represent yourself or see if you can get a pro bono attorney or legal aid, because the Legal Aid Society does represent poor people in divorce cases, albeit relatively limited. But that's your really only avenue if your spouse is not moneyed and doesn't earn income of close to six figures or above and doesn't have significant assets or property to dip into to get an award of counsel fees. But in the vast majority of divorce cases that I'm aware of, the party is able to get a counsel through one of those three methods.